Revenue and Taxation.
Section 169. Fiscal Year. The fiscal year shall commence on the first day of July in each year, unless otherwise provided by law. The previous constitutions did not contain provisions concerning taxation. The General Assembly had in 1882 adopted the same fiscal year, as defined in Section 169. In the opinion of the Attorney General, a fire protection district created and organized pursuant to a state statute and county governments is subject to the fiscal year adopted by Section 165 unless provided otherwise by statute.
Section 170. Property exempt from taxation. Cities may exempt factories for 5 years. There shall be exempt from taxation public property used for public purposes, places of burial not held for private or corporate profit. Real property owned and occupied by, and personal property both tangible and intangible owned by, institutions of religion, institutions of purely public charity, and institutions of education not used or employed for gain by any person or corporation, and the income of which is devoted solely to the cause of education, public libraries, their endowments, and the income of such property as is used exclusively for their maintenance. Household goods of a person used in his home, crops grown in the year in which the assessment is made, and in the hands of the producer. And real property maintained as the permanent residence of the owner, who is 65 years of age or older, or is classified as totally disabled under a program authorized or administered by an agency of the United States government or by any retirement system either within or without the Commonwealth of Kentucky. Provided the property owner received disability payments pursuant to such disability classification, has maintained such disability classification for the entirety of the particular taxation period, and has filed with the appropriate local assessor by December 31st of the taxation period. On forms provided therefor, a signed statement indicating continuing disability as provided herein made under penalty of perjury up to the assessed valuation of $6,500 on said residence and contiguous real property, except for assessment for special benefits. The real property may be held by legal or equitable title, by the entireties, jointly, in common, as a condominium or indirectly by the stock ownership or membership representing the owners or members' proprietary interest in a corporation owning a fee or a leasehold initially in excess of 98 years. The exemption shall apply only to the value of the real property accessible to the owner or, in case of ownership through stock or membership in a corporation, the value of the proportion which his interest in the corporation bears to the assessed value of the property. The General Assembly may authorize any incorporated city or town to exempt manufacturing establishments from municipal taxation, for a period not exceeding 5 years, as an inducement to their location. Notwithstanding the provisions of Sections 3, 172, and 174 of this Constitution to the contrary, the General Assembly may provide by law an exemption for all or any portion of the property tax for any class of personal property. The framers of the current Constitution intended Section 170 as a limitation on tax exemptions, which, they argued, had grown to excessive amounts by the date of the Constitutional Convention. One delegate submitted that 1/4 of the property of Louisville had been exempted from taxation, while Governor Simon B. Buckner contended that exemptions had placed a substantial burden on those whose property was taxed. Buckner argued unsuccessfully for even greater limitations on exemptions, including the elimination of the exemption for religious property. A series of amendments have broadened the scope of Section 170 to include a total exemption, originally set at $250, for household goods, in 1955, a homestead property tax exemption of $6,500 for single-family residences of individuals aged 65 or older, in 1971. An extension of the $6,500 homestead property tax exemption to non-single-family residences, in 1975, a $6,500 homestead property tax exemption for the residences of those classified as totally disabled by the federal government or the railroad retirement system, in 1981, and an exemption for all religious property, in 1990, which was originally extended to only the church and manse. In 1998, voters ratified an amendment that extended the homestead property tax exemption to those classified as totally disabled by the federal government or any public or private retirement system and authorized the General Assembly to exempt motor vehicles and any other class of personal property from the levy of all or any portion of the property tax. A statute enacted in 1974 enlarged the $6,500 exemption by pegging it to the purchasing value of the dollar as of 1972. The Kentucky judiciary has ruled that the property of a Masonic lodge devoted to charitable purposes, in Commonwealth v. Grand Lodge of Kentucky, 1970, a children's theater, in Department of Revenue v. Louisville Children's Theater, 1978, and a private history society that operates a library open to the public, in City of Louisville v. Filson Club, 1956, are exempt from taxation, but not the property of an Elks Lodge that engages in a number of non-charitable activities, in Benevolent Association of Elks v. Wintersmith, 1924, an American Legion post that functions mostly as a private club, in American Legion v. City of Louisville, 1958, or a non-profit gymnastic association that serves no educational purpose, in German Gymnastic Association of Louisville v. City of Louisville, 1948. The judiciary further ruled that Section 170 does not empower the General Assembly to exempt real estate entirely from taxation, in Martin v. High Splint Coal Company, 1937, that real estate leased by a charity to a for-profit business is non-exempt, in Trinity Temple Charities Incorporated v. City of Louisville, 1945, and that a local school board is not exempt from a sewer use fee since it is not a tax, in Fayette County Board of Education v. Lexington-Fayette Urban County Government, 1985. The conversion of an existing manufacturing establishment to a facility producing different products entitled it to a 5-year exemption, in Voigt Brothers Machine Company v. C., 1918, but the installation of new machinery to manufacture the same products did not qualify for such an exemption, in B.F. McCormick Lumber Company v. City of Winchester, 1913.
Section 171. State tax to be levied, taxes to be levied and collected for public purposes only and by general laws, and to be uniform within classes, classification of property for taxation, bonds exempt, referendum on act classifying property. The General Assembly shall provide by law an annual tax, which, with other resources, shall be sufficient to defray the estimated expenses of the Commonwealth for each fiscal year. Taxes shall be levied and collected for public purposes only and shall be uniform upon all property of the same class subject to taxation within the territorial limits of the authority levying the tax, and all taxes shall be levied and collected by general laws. The General Assembly shall have power to divide property into classes, and to determine what class or classes of property shall be subject to local taxation. Bonds of the state and of counties, municipalities, taxing and school districts shall not be subject to taxation. Any law passed or enacted by the General Assembly pursuant to the provisions of or under this amendment, or amended section of the Constitution, classifying property and providing a lower rate of taxation on personal property, tangible or intangible, than upon real estate shall be subject to the referendum power of the people, which is hereby declared to exist to apply only to this section, or amended section. The referendum may be demanded by the people against one or more items, sections, or parts of any act enacted pursuant to or under the power granted by this amendment, or amended section. The referendum petition shall be filed with the Secretary of State not more than 4 months after the final adjournment of the Legislative Assembly which passed the bill on which the referendum is demanded. The veto power of the governor shall not extend to measures referred to the people under this section. All elections on measures referred to the people under this act shall be at the regular general election, except when the Legislative Assembly shall order a special election. Any measure referred to the people shall take effect and become a law when approved by the majority of the votes cast thereon, and not otherwise. The whole number of votes cast for the candidates for governor at the regular election, last preceding the filing of any petition, shall be the basis upon which the legal voters necessary to sign such petition shall be counted. The power of the referendum shall be ordered by the Legislative Assembly at any time any acts or bills are enacted, pursuant to the power granted under this section or amended section prior to the year of 1917. After that time the power of the referendum may be ordered either by the petition signed by 5% of the legal voters or by the Legislative Assembly at the time said acts or bills are enacted. The General Assembly enacting the bill shall provide a way by which the act shall be submitted to the people. The filing of a referendum petition against one or more items, sections or parts of an act, shall not delay the remainder of that act from becoming operative. By the date of the Constitutional Convention of 1890 to 1891, observers complained that corporations, especially banks, were undertaxed, and that property generally was unevenly assessed. To help remedy these problems, the framers of the current Constitution provided in Section 171 that all taxable property should be taxed at the same rate. By the early 20th century, critics complained that requiring all property to be taxed at the same rate resulted in inequities, and that classifying taxable property and allowing each class to be taxed at different rates represented a fairer tax system. For example, under the original system, owners of intangible property such as stocks and bonds theoretically were required to pay the same rate of tax on their holdings as owners of tangible property and real estate. If paid, the tax would have absorbed as much as 2/3 of the income derived from the ownership of intangible property such as bonds, and thus many owners of such property either failed to list it for taxation or omitted much of it. Experts argued that permitting the General Assembly to put intangible property into a separate class and lowering the tax on that property would encourage a much more substantial compliance with the tax law and actually raise much more tax revenue. Voters approved an amendment to Section 171 in 1915 that authorized the General Assembly to divide property into classes, which property could be taxed by the state and local government at different rates, although within each class the rate should be uniform. The section exempts from taxation state, local governmental, and school bonds, some of which also had been taxed under the original section, a reality that forced those governments to pay bondholders a higher rate of interest. The amended section also provides that if the General Assembly imposes a lower tax on personal property, tangible or intangible, the Assembly or 5% of the legal voters can initiate a referendum on the tax, which must be approved by a majority of the votes cast in the referendum to become effective. The Kentucky Court of Appeals has held that Kentucky's income tax is not a property tax and thus is not subject to the Section 171 uniformity provisions in Reynolds Metal Company v. Martin, 1937. The Kentucky Supreme Court declared in Gillis v. Yount, in 1988, that a tax on unmined coal at a rate lower than other unmined minerals is unconstitutional as an arbitrary classification under Section 171. Also ruled unconstitutional were the selection of citizens of the United States who are domiciled in a foreign country as a class on which to impose an estate tax, in Burge v. Markham, 1965, and the grouping of grandchildren into a separate class depending on whether they are descended from living or deceased children of the decedent for inheritance tax purposes, in Kentucky Tax Commission v. Lincoln Bank Trust Company, 1952. In a landmark case, the Court of Appeals held in 1908 that license taxes must be uniform, but need not be levied on all trades, occupations, or professions, and that different fees may be imposed on each class into which a trade, occupation, or profession may fairly be divided, in Hager v. Walker, 1908. The court held that while the General Assembly's determination that a certain tax is for a public purpose is not binding upon the judiciary, it did agree with a legislative declaration that taxation to benefit agricultural extension work and home economics was intended for a public purpose, in Carman v. Hickman County, 1919. It also held that a bonded debt for the purpose of relieving unemployment is a debt created for a public purpose as required by Section 171. In Deitch v. City of London, 1956, but that a voluntary donation of public funds by a municipality for other than public purposes violates this section, in Caudle v. Pin-Zion, 1930, as do direct payments by a fiscal court to privately owned schools for school transportation, in Fiscal Court of Jefferson County v. Brady, 1994.
Section 172. Property to be assessed at fair cash value, punishment of assessor for willful error. All property not exempted from taxation by this Constitution shall be assessed for taxation at its fair cash value, estimated at the price it would bring at a fair voluntary sale. And any officer or other person authorized to assess values for taxation, who shall commit any willful error in the performance of his duty, shall be deemed guilty of misfeasance, and upon conviction thereof shall forfeit his office, and be otherwise punished as may be provided by law. This section directly addresses a major deficiency of the tax system of 19th century Kentucky, namely, the inequality and inconsistency of assessment from county to county. Critics complained that assessors in some counties deliberately underassessed taxable property, while those in other counties assessed at full cash value so that property worth far less in some places was taxed the same as property in other places that was in fact worth far more. This section not only requires tax assessment at fair cash value but provides penalties for assessors who commit willful errors in their assessments. County tax assessors largely ignored this section with impunity until 1965, when the Kentucky Court of Appeals ruled in Russman v. Luckett that the continued violation of Section 172 had not implicitly repealed the section and that, as of January 1, 1966, strict compliance with the provision would be required. Although as a result of this decision assessments in Kentucky generally increased and became more uniform, a series of articles in the Lexington Herald-Leader in 1989 revealed continuing deficiencies in certain counties. However, according to a Legislative Research Commission study published in 1993, tax assessment levels in Kentucky since the Russman decision have been among the highest in the nation. The Kentucky judiciary has held that there was no violation of Section 172 when a local property valuation administrator divided his county into 4 sections, with one section to be assessed each year, in Commonwealth, Revenue Cabinet v. Leary, 1994. However, a property valuation administrator may not assess property at greater than its fair market value, in Barrett v. Reynolds, 1991.
Section 172A. Assessment for ad valorem tax purposes of agricultural and horticultural land. Notwithstanding contrary provisions of Sections 171, 172, or 174 of this Constitution, the General Assembly shall provide by general law for the assessment for ad valorem tax purposes of agricultural and horticultural land according to the land's value for agricultural or horticultural use. The General Assembly may provide that any change in land use from agricultural or horticultural to another use shall require the levy of an additional tax not to exceed the additional amount that would have been owing had the land been assessed under Section 172 of this Constitution for the current year and the 2 next preceding years. The General Assembly may provide for reasonable differences in the rate of ad valorem taxation within different areas of the same taxing districts on that class of property which includes the surface of the land. Those differences shall relate directly to differences between non-revenue producing governmental services and benefits giving land urban character which are furnished in one or several areas in contrast to other areas of the taxing district. Voters approved this section as a constitutional amendment in 1969 in order to benefit owners of farmland near urban areas. As long as such land continues to be used for agricultural or horticultural purposes, it will be assessed as farmland and not as land with the potential for more profitable, non-agricultural use. Each year such land shall be assessed at its fair market value as farmland and its fair market value as non-farmland. If the use of the land changes from farm to non-farm purposes, additional taxes are due not only for the year of the change, but also for the 2 previous years. The Kentucky Supreme Court has ruled that Section 172A does not permit a property valuation administrator to use, by mechanical application, comparable sales or income-producing capacity to evaluate farmland near a city, or even to use the recent sales price of the land in question. Rather, the assessor must value the land on the assumption that it will be restricted by law, for the indefinite future, to agricultural and horticultural uses, in Board of Tax Appeals v. Jess, 1976. The court also ruled that Section 172A does not permit a property valuation administrator to use a mathematical formula to assess farmland without additionally considering the peculiar characteristics of the property in question, in Dolan v. Land, 1984.
Section 172B. Property assessment or reassessment moratoriums. Notwithstanding contrary provisions of Sections 170, 171, 172, or 174 of this Constitution, the General Assembly may provide by general law that the governing bodies of county, municipal, and urban county governments may declare property assessment or reassessment moratoriums for qualifying units of real property for the purpose of encouraging the repair, rehabilitation, or restoration of existing improvements therein. Prior to the enactment of any property assessment or reassessment moratorium program, the General Assembly shall provide or direct the local governing authority to provide property qualification standards for participation in the program and a limitation on the duration of any assessment or reassessment moratorium. In no instance shall any such moratorium extend beyond 5 years for any particular unit of real property and improvements thereon. In 1981, the voters approved an amendment adding this section, which authorizes local governments to declare moratoriums on the tax assessments or reassessments of certain real property in order to encourage the owners to repair, rehabilitate, or restore such property. Pursuant to the mandate of this section, the General Assembly has enacted statutory guidelines for its implementation by local governments. In the opinion of the Attorney General, moratorium programs established by certain local governments pursuant to Section 172b cannot limit the assessments or reassessments of property for purposes of the imposition of ad valorem taxes by other local governments and the state. Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.